Good evening, folks. My name is Greg Perrick. I'm from Community Legal Services Clinic at Western Ontario. I am the Family Law Review Counsel here. It's a student-run clinic. We do work in family law, in criminal law, and civil and administrative law. Tonight, we're going to be doing a somewhat brief but helpful presentation on financial issues, motions and case conferences. We have three students here tonight that are going to do each section. And at the end, there's going to be a Q&A, but they will talk about that. We appreciate folks attending and watching tonight. This will also be recording at this time. This recording will be boosted and shared in multiple languages by Rights and Responsibility Awareness Initiative. Heath Karki is on the line here, and we're very thankful for his partnership in making it possible for the messages that we have to give to folks for family law issues. We're thankful for him boosting that loud and clear to everybody. So thank you for that. What I'm going to do now is I'm going to pass it to Julia, who's going to start off the presentation. Thank you for that.
All right, thanks, Greg.
Sorry, just a second here.
So,
I'm going to share the full screen. I think I do this each and every time. Why don't you start, Julia, and I'll figure out how to get
sure.
full screen here. Thank you.
Sounds good. So my name is Julia. I'm a 1L associate caseworker at CLS at Western Law, and I'm really excited to be here talking to you today about financial issues, motions, and case conferences in the family law context. I would like to start with a land acknowledgement. We can go to the next slide.
Yes.
All right. So I acknowledge that Western University is located on the traditional lands of the Anishinaabeg, Haudenosaunee, Lenapehouk, and Chinangtan nations on lands connected with the London Township and Sombra Treaties of 1796 and the Dish with One Spoon Covenant Wampum. With this, I respect the long-standing relationships that Indigenous nations have to this land, as they are the original caretakers. I acknowledge historical and ongoing injustices that Indigenous peoples, First Nations, Métis, and Inuit endure in Canada. And we at Western accept responsibility as a public institution to contribute towards revealing and correcting miseducation as well as renewing respectful relationships with Indigenous communities through our teaching, research, and community service. Just a quick disclaimer that this isn't a legal advice session. It is a public legal education session that will provide basic and general information with respect to be spoken to appearances. Now, there will be a Q&A session at the end of the presentation where you'll be able to ask the lawyer questions at that time. A reminder that only general advice can be given, so do not rely on this information as specific advice for your own specific circumstances. Oh, there we go. All right. So there's no confidentiality provided during this presentation nor during the Q&A session. It is being recorded for the public and it is streaming on Facebook for other folks as well. So if you don't want the public to know about any private matters that you have, please do not mention them during the Q&A session. Now, public legal education presentations are given by law students at Western Law, such as myself and my two other colleagues here with us today. And so, despite their growing knowledge of the law, we still cannot give legal advice during any time of this presentation. So, I'm going to get into the first topic, which is financial issues. I'm going to start with talking about Form 13 financial statements. So, this is a form that must be sworn, served, and filed whenever parties are making financial support claims. There are also a Form 13.1 financial statement that must be alternatively completed in other circumstances. However, we don't do property cases at CLS. Now, this form will be required to serve and file in some of the following scenarios. If a child support claim is being made against our client, if a child support claim is being made by our client, but they have care of the child or children on a shared basis within a 60 to 40% split, if a spousal support claim is being made by or against our client, if a Section 7 expenses claim is being made by or against our client. Now, this list is non-exhaustive, meaning there are a lot of other possible scenarios where a Form 13 will be required to file. Now, this form must be served and filed along with the following additional documents. Notices of assessment from um, the last 3 years full income tax returns, and the most recent income stub. So, what is an income tax return? This is essentially the form that you submit to the Canada Revenue Agency, otherwise known as the CRA, in order to claim your income, your expenses, any deductions and exclusions for that given tax year. It's especially important for the court and the opposing party to see if you are self-employed because if this is the case, they'll be interested in knowing what expenses you're claiming because this could reduce your income in an unreasonable way as far as child support guidelines are concerned. Now, your income for child support purposes is in accordance with your gross income, which is the total amount that you make per year, and not your net income, which is the number arrived at after any tax deductions, deferrals, and exclusions are considered. It's also really important to obtain the full tax return and not just a summary of it because the opposing parties are entitled to the full tax return and they can insist on it until they receive it. Now, a notice of assessment or an NOA is what you get back from the CRA when you submit your income tax return. And your NOA is an evaluation of your tax return. It includes the date the return was processed by the CRA, as well as any other details about how much you may owe or get as a refund or credit. So essentially, any details about your tax return are going to be on this NOA. Now, why is this important? It's important for a number of reasons. So the first being that it constitutes a proof of income because it verifies your annual earnings, which are used to calculate and later determine child and spousal support obligations under our federal guidelines. It ensures transparency and prevents underreporting or hiding income in financial disclosures. It assesses financial needs and one's ability to pay, which can help courts evaluate who needs support and who can pay. It aids in any kind of property division. So, when it comes to asset divisions or dividing assets and debts, this will confirm the relevant income sources to that. Lastly, it ensures compliance because it can be cross-checked with other financial records to verify accuracy. All right, so here are just some examples of the different types of income sources. These are just a few of many, but um, first it would be your employment income, so your regular wage or salary from your job. The next would be any kind of social assistance, which is government financial aid for those in need. It can be Ontario Works or Welfare, to name a couple of them. This could be coming from the Canada Pension Plan disability benefits, which is financial support for people with severe and prolonged disabilities, which prevent them from working. Canada Pension Plan, which is monthly retirement benefit for individuals who contribute to the Canada Pension Plan during the time that they're working. There's OAS, which is Old Age Security, which is a government-funded pension for seniors age 65 and above, which is based on residency in Canada. And there's EI, or Employment Insurance, which is a temporary form of financial assistance for those who aren't working. Now, this list isn't exhaustive either. There's a bunch of other income sources as well. All right, so now I'm going to talk about Section 7 expenses. And in Ontario, these are extraordinary or special expenses for a child, in addition to regular child support. A court may order one or both of parents to contribute to these. And according to federal guidelines, these are defined as expenses that are necessary because they're in the best interest of the child or that they are reasonable given the means of the parents and the child in light of the family's spending patterns before the separation. Now, special or extraordinary expenses are childcare expenses that you might have to pay as a result of a job, an illness, a disability, or educational requirements for employment if your child spends the majority of the time with you. It could be the portion of your medical and dental insurance premiums that provide coverage for your child. It could be healthcare needs that exceed $100 per year if the cost is not covered by insurance. This could be counseling, medication, eye care, orthodontics, etc. This could also be expenses for post-secondary education, extraordinary expenses for your child's primary, secondary education, or any other educational program that may meet your child's particular needs. And this would also include expenses for your child's extracurricular activities. So, these expenses for education or extracurricular activities are considered extraordinarily only if they are more than you can reasonably pay based on your own income and the amount of child support that you're receiving, or if they're not more than you can reasonably pay, but they're extraordinary when you take into account your income and the amount of child support you receive, the nature and number of educational programs and extracurricular activities, and the overall cost of those, any special needs or talents of the child, and any other similar factors that may be considered relevant. Now, of course, it's best if you agree on which special or extraordinary expenses are reasonable and necessary in your situation, and you may include expenses that you expect to have sometime in the future as well. So, some things to think about when considering Section 7 expenses is that when you're setting up your child support agreement, it's also a good idea to include the particulars of each expense. So, what it's for, a couple examples here might include hockey, soccer, dance lessons, music lessons, anything like that, the total cost of them, how much you each will contribute to the cost. The date payments are due, and any other information you think might be relevant. Now, essentially, this will help you to avoid any kind of misunderstandings or conflict in the future, and it might make it easier to enforce expenses if need be. And these can usually be enforced only when the support agreement or order includes a specific dollar amount for each expense. So, in general, it's best to be precise and specific. So, a couple bottom line takeaways from this is that the best thing you can do in your case is get all of your financial disclosure together at the very beginning of the case, so it's better sooner rather than later. Otherwise, you might not be able to proceed with your case, and or the court may take more of an unfavorable view on your case because of this lack of disclosure. And lastly, always keep your children's best interest in mind when making these decisions. Thanks so much, and I'm going to pass it off to my colleague Thea.
Thanks, Julia. I'm going to be talking a bit about temporary motions. So, temporary motions are heard in person every Wednesday starting at 10 a.m. in the London courthouse. The moving party, so the person starting the motion or the applicant, has to file their Form 14 Notice of Motion, Form 14A Affidavit, and Form 6B Affidavit of Service no later than 6 business days prior to the hearing date, not including weekends. Then the responding party or the respondent must serve and file the responding affidavit no later than 4 days prior to the hearing date. If the moving party has a right of reply, they must serve and file their response no later than 3 days before the hearing date. All evidence on a motion that will be read by the judge the night before the hearing must be served and filed no later than 3 days before the hearing. There are rare exceptions where you will have to try to hand up your reply affidavit on the day of the hearing, but it's always better to try and comply with these filing deadlines. So reply affidavits can only be done if the responding affidavit raises fresh allegations against the moving party. It's improper to use the reply affidavit to instead clarify, amend, or elaborate on previous allegations that you already made in your initial affidavit. If the other side provides a response to your initial allegation that you weren't expecting, that does not mean that you get to reply to it. And not following this rule is a very easy way to get the judge annoyed with you, so try to stick to it. When you are arguing your motion in court, you will be asked if you are the moving party if you have any reply submissions. And again, you should only rise to make these submissions if your points fall under the principles of proper reply just outlined. So only use this option if the respondent raises fresh allegations against you. So moving on, Form 14, Notice of Motion. This form tells the opposing parties and the court a bunch of information, so namely who is bringing the motion, who they are bringing the motion against, where the motion is to be heard, when the motion is to be heard, the method of the appearance, so if it's going to be online or in person, what documents are to be read in support of the motion, how to respond to the motion, when to respond to the motion by, and what orders the moving party is asking the court to make if they are successful. So the orders requested should be numbered and written in the same way that you want them read in the order if the judge rules in your favor. And the Ontario Court Forms website has a standard clauses form for family law that's useful for helping to write these orders. If you do not make a specific request in a notice of motion, note that the court has the right to ignore that request. So for example, if a party does not ask for the costs in their motion, so the costs from having to bring the motion forward, then even if they are ultimately successful in their motion, the court can still deny the request for costs. So on the slide, these are some example requests that you would make in a Form 14. So number 1, the applicant shall have primary care of the child. Number 2, the respondent shall have parenting time with the child at the stated dates and times. Number 3, commencing immediately, the respondent shall pay child support to the applicant in accordance with their annual income and the child support guidelines. Number 4, costs. So if the motion is ruled in favor of the applicant, costs for bringing the motion forward. And number 5, such further and other relief that this honorable court may deem fair and just. So any other orders that the court deems are necessary and appropriate. So moving on, Form 14A affidavit. This is where you make your and any other witnesses' allegations to support the requests you are making in your notice of motion if you're the moving party, or it's where you respond to the allegations made against you in a motion if you are the respondent. So an affidavit is personal testimony and should be in plain language as much as possible. An affidavit should be confined to factual allegations and factual responses only. For short or regular motions, each party has one primary affidavit in support of their position on the motion and cross motion if applicable. And this should be a maximum of 12 pages. If a party also intends to rely on an affidavit that has previously been filed with the court, the length of that affidavit is included in this 12-page limit. However, this limit does not include third-party and reply affidavits where required. These shall not exceed 5 pages each, and it also doesn't include affidavits relating to a party's financial statement in accordance with Rule 1312B. So exhibits are any documents such as financial statements, photographs, receipts, letters, and reports that are attached to each party's affidavit. An exhibit should be limited to only the necessary and relevant evidence, so they're generally a maximum of 10 pages. So exhibits should not include long texts, emails, and/or social media postings. Only the relevant and necessary parts of these communications should be attached to affidavits as exhibits. So these are some examples of things that you might want to include in a Form 14A. So you'll notice that each sentence is its own point, and it's numbered. So first, you might want to start with the relationship with the respondent, and then you could move to when the relationship began, when you began living together, any dependents, when you separated, your current living situation, and the current parenting arrangement. Then you can move into making specific requests. So if you're asking for parenting arrangements, you can put that you would like more time with the dependent child and then use subsequent points to outline the reasons why you are requesting more time with the dependent child. Then you could move into decision making, make a point like I would like joint decision making, and then use subsequent points to outline the reasons why you are making this request. So Form 6B is the affidavit of service. This has the names and addresses for service for the applicants, respondents, and lawyers for both parties, if applicable. Form 6B has the date and time the person to be served was served with case documents, the list of documents served, so for example, Form 14 and Form 14A, the method of service, so email, mail, fax, etc., and the relationship or affiliation with any parties in the case. If you serve by fax, email, or electronic document exchange, the first page of the correspondence should include the date and time of service, the sender's name, phone number, and fax or email address, the name of the person or lawyer to be served, the total number of pages served, the title or description of the document, and the name and phone number of the person to contact if there are any technical difficulties receiving the documents being served. Lastly, I just want to quickly mention Form 14C. This is a final step to have your temporary motion heard. So before your temporary motion can be heard, you have to file and serve a Form 14C or confirmation of motion form. And this form must be served and filed at least 3 days before the hearing by 2 p.m. So I'm going to pass it on to Michael to talk a bit about case conferences.
Thank you so much, Thea. So, like Thea said, the next and final topic for our public legal education seminar will be case conferences. So, what is a case conference? Well, it's the first very important step for family law court procedures because it's where you will have the full undivided attention of a judge for the first time typically. A case conference is primarily used to deal with procedural matters, so helping to keep the case on track and moving efficiently throughout the court process from start to finish. What it isn't, however, is a place for a judge to provide a substantive ruling on the case, because that typically comes later. That said, judges at a case conference can offer non-binding recommendations to help the parties reach an agreement or settle part of a case. In many situations, this early guidance can encourage resolution and reduce the need for lengthy litigation, which helps save everyone time, money, and stress. Everyone involved at the case conference, whether they have a lawyer or not, has the opportunity to share their perspectives. The goal is to help resolve or narrow the issues and promote cooperation between the parties to ideally resolve disputes. Next slide, please. In addition, a case conference serves many other purposes. For instance, if financial disclosures remain outstanding, the judge might make an order requiring either party to give the other party the necessary documents. So once again, this kind of ties back to what Julia was mentioning earlier. So this could include records of employment, corporate tax information, payroll records, bank statements, mortgage applications, Children's Aid Society disclosure, Child Protection Service notes, intake notes, family planning notes, consents to release information, police disclosures, occurrence reports, child interview notes, transcripts, officer notes, etc. Basically anything that the court or the judge might need to help resolve the issue. It should also be noted that since all case conferences are informal meetings, they might all look a little differently. So the list we provided is not exhaustive. For instance, case conferences might also be used to identify any witnesses and other evidences that might be presented at trial, or estimating the time needed for trial if the case is not resolved. Next slide, please. As for how a case conference proceeds, the requirements are outlined clearly in the Ontario Court Form's website, so that's where you would go if you were just starting out. Before a case conference takes place, both parties must serve and file their case conference briefs in accordance with the family law rules. Now, these briefs are available on the Ontario Court Form's website and they're numbered 17A. The timelines for these are important. The applicant or the moving party in a motion to change, or whoever has requested the conference, must serve and file their brief at least 6 business days before the conference. The respondent, on the other hand, has 4 business days before the conference to serve and file theirs. Now, this is a key point to mention. The respondent must file their brief even if the applicant hasn't yet served theirs. As a respondent, your brief isn't really a response in the traditional sense, in the case that it's not really dependent on what the other side has filed. Instead, it's supposed to stand on its own. It should focus on the facts, issues, and procedural steps that you believe are necessary at this stage. So if you're the respondent, you definitely don't want to wait for the other side to file their case brief. You want to get yours in on time and make sure that your position is clearly laid out. If you fail to serve a case conference brief on time, the case conference might not go ahead and the other party would be entitled to costs. Now, this cost can range anywhere from $500 to $1,000 conservatively. As such, it's really important for case conference briefs to be filed as soon as possible by you or your representing lawyer. Once you've served the case conference brief to the other party, I want to also mention that you must complete and file an affidavit of service form 6B. Now, what this form does is it basically confirms that you properly served documents, when and how the service took place, and to whom. In addition to that, you should also file a confirmation of conference, Form 17F. This form tells the court that you're ready to proceed with the case conference and confirms that all required materials have been filed and served, as well as list the issues you want to discuss. Now, all of these forms are essential to keep your case conference scheduled. So if you don't file them properly on time, the court may remove your case from the list, and then you'll kind of be back to square one. Finally, if your case involves financial issues, you may be required to provide updated financial statements and serve it along with the rest of your documents. Next slide, please. Finally, case conferences are closed appearances, so whatever that might be said in the meeting is private and confidential. Otherwise, no party would try to settle or feel comfortable enough to negotiate, knowing that what they might say during negotiations could be used against them later. Although the judge can offer advice for how the case should proceed, what you choose to do with that information is up to your discretion. At the end of the conference, the judge will also document that the case conference occurred by writing a note called an endorsement to be added to your court file. You will also obtain a copy of this endorsement, which you can reference as the case extends itself. And lastly, before I conclude, I want to mention a couple of interesting resources that might be helpful if you are new to CLS and public legal education in general. So the first one I want to highlight is actually the Community Legal Services Court Assistance Program. So what this kind of is it's a program that we started back in December of 2024, and it's basically meant to assist unrepresented parties that might not qualify for legal aid, but still otherwise can't afford a lawyer. So what this service does is we provide assistance to those who have court matters by helping them out with procedural matters. So for example, we might give them options for next steps, give them tips on how to do a case conference, how to organize a settlement conference, and how to bring a motion. It should be noted, though, we can't give specific advice on the case unless we're sorry. So it should be noted we can't give specific advice on the case because that would be a role reserved to duty counsel or legal aid. And a couple of other services to highlight: lawyer referral service, crisis line, steps to justice, and as you all may know, Legal Aid Ontario, which is where you would obtain your certificate, find a lawyer, and basically the funding body that makes CLS services possible. Thank you so much.
Hey, thank you very much, folks. I'm going to stop sharing the screen here. Thank you to all three of you. That was very, very well done and well put for the public. Again, this is just bite-sized information, basic information that we think is helpful for unrepresented parties and how to move through their case. Yes, so thank you. Heatham just sent a message through the chat thanking us. Thank you again, Heatham. We really, really appreciate it. And we'll send this recording over to you so you can boost that for everyone. So thank you again for that. Just a couple of things I wanted to not clarify or change. The students all did a great job. Probably just emphasize. The one thing that I think is very important for folks who want to bring a motion and want to hear or participate in case conferences is the confirmation of motion, 14C form, and the confirmation of conference, the 17F form. You should get those in as much as possible 3 business days before. You can email that to the court, or you can take it to the court office. but it has to be done by 2 p.m. on that third day. Because I've seen lots of folks in court, and you know, I get it when you're not a lawyer, this is not something that is top of mind. And in fact, I forgot it before, and I've seen my colleagues forget it before, doing a confirmation. And if you don't do that, there's a chance that your matter may not be heard at all that day. And as you can imagine, that's a frustrating experience. For motions, if you don't have your matter heard, um, because of that, it could just get adjourned over to the next Wednesday, which you would have to confirm again. But for conferences, it could be a little more consequential because the conference, settlement conferences and case conferences, um, they're often few and far between as far as scheduling goes. So if you don't do your confirmation of conference, and the conference doesn't go ahead for whatever reason, you may not have another one for a while. Um, and and we won't get into the details today, but you may not be able to then, if you want to bring a motion, because typically you're not able to bring a motion until you've had a case conference. You want to bring a motion for child support or to set the parenting schedule in stone, try to get something stable. You won't be able to do that because you haven't had your case conference. So it's really important that you make sure that you do your confirmations and you send them in. Um, I can't stress that enough. And again, I speak from experience. As a lawyer, when I first started out, that was something that I would forget from time to time. And I would be like, it's just a confirmation. What really matters is my affidavit, my Form 14 notice of motion. And that's not true. The confirmation of motion and confirmation of conference is so important because it lets the court know, the judge specifically, what to read the evening before or whenever they decide to read the material. And those forms tell the court what to read. And if the judge doesn't know what to read, they're not going to read anything, because well, what are you going to do? Just go into the file and figure out, oh, maybe this is what they want me to read. They're not going to do that. There are too many matters, especially these days. I'm sure folks who have been in court have experienced the backlog. So judges can't be guessing at what to read. You have to do these confirmations of motion and conference to let them know what to read. If you are unsure of how to fill out those forms, contact legal aid, contact duty counsel. If you don't qualify for their services or otherwise not getting in contact at the right time, you can email us at clscap@uwo.ca, and maybe that's something we can help you with. Excuse me, sorry. I'm not saying that that's what we can certainly help with, but we are another resource that folks can reach out to see if we can help. Um, for unrepresented parties, the court expects unrepresented parties to be as ready and as prepared as lawyers. That's a high expectation, as you can imagine. So make sure that you're doing your due diligence in getting your paperwork together. And if you have a question about it, and I imagine folks will, because it is overwhelming stuff. There are so many different forms that we all have to deal with, and it can be a lot. So if you are wondering how to fill out forms, don't hesitate to call one of the resources that we put in this slide. Because as someone who likes to stick their head in the sand and avoid things from time to time, or used to, I get the feeling. But that it's not going to advance your case. It's not going to get better. And the judge who won't know your case at all is going to probably just adjourn it over. So please, please, if nothing else, take that to heart, because we want folks to be prepared, lawyers and non-lawyers alike, because we want the system to move as smoothly as possible. The courts are busy. And so anything that we can do to help folks address those kind of small issues that create problems, if you can address those, and so you can be before the court to say the things you want to say, um, please do that. Watch this recording over again if you want. That's why it's recorded. And thank you again to our AI for doing that for us, because I think it's very important. I Being a lawyer, you notice these smaller things that you maybe at first glance you don't think are important, but really form the basis and the foundation for you to be able to do things you want in court. It's a frustrating experience for unrepresented parties to go to court and not be able to have their matter heard that day. And it can become a defeating process. It can feel helpless. You're like, I'm never going to get this right. What am I doing? I don't know if this is worth it at all. But it is worth it because you're there, right? And if you can, reach out to resources like this, like Duty Council, like Legal Aid, like PBSC, Family Justice Center, things like that are in place to help you. Don't be afraid to ask for help. I tell my students all the time that the law, even for lawyers, is overwhelming, and we're always learning new things all of the time. So don't think that even as an unrepresented party, even though the expectation is that you're going to be as knowledgeable as a lawyer, don't be intimidated by that. You ask for help, and don't stick your head in the sand, because it won't get better if you don't reach out for help. Um, I'll probably stop ranting at this point, but that is really something that I want to make sure that folks recognize, that doing your confirmations, doing the work, and meeting the deadlines that the students have set out for you tonight, that's so important. And the one thing, and it's my fault I didn't add this, if you don't meet the deadlines, at least where conferences are concerned, um, say you are trying to file your case conference brief, you're the one who started it, so you have to do it 6 days before, business days, not including weekends, and you miss that. You can always still try to get it done, and I encourage you to do so. It's not an all or nothing proposition. You can still try to get it done, still serve it on the other side, and ask for what's called a consent to late filing. And that is another form that you can look at and pull up on Ontario Court Forms website. And that's something that you can send to the other party or their lawyer if they have one, and see if they will consent to you late filing. And that's a form that they would sign, and you would have to say when you're going to serve it by. But even as a lawyer, when I was first starting, I really treated it like a all or nothing approach, and I would kick myself because I was like, oh, I forgot I didn't meet the deadline, so I guess I can't get it in. Still try to get something before the court, because that's still helpful for the judge, and maybe it will save you from having the matter adjourned, and maybe it will save you from a wasted appearance where the other side could ask for costs, the legal fees that the other side may have incurred, or maybe they don't have a lawyer and they're asking for, well, I took the day off work and I want costs for that. Always be trying to at least get your material in. And even if you don't get it in prior to that day, and this is in the conference context, not the motion context. If you can't get your material in on that day, make sure you still or in time, make sure you still confirm. And in the meantime, do your confirmation of conference. And in the meantime, still work on that brief, that case conference brief, and get it into the other side. Because then you may be able to hand it up to the judge on the day. In the London region, case conferences are presumptively in person. That means it needs to happen in person. You should be prepared to go there, even if you do live outside of this district. And then on the day, you may be able to hand it to the court registrar, who, if the judge allows it, will be able to read it on the day. That's better than nothing. And so make sure that you're always kind of striving to get that information in, because it may not be too late. But apart from that, and it was said during the presentation, endeavor to get it done in time. The court appreciates organization and being prompt and timely and following the rules. And that will get you a long way. It will, again, allow you to say the things you want to say in court in the time that you need to say them. So I wanted to say that. And the other thing I wanted to clear up is, so we talked about applicant and respondent tonight. Those could be interchangeable, or not interchangeable, but those could be used in a different context. The applicant is not always the person who starts the matter, or who is supposed to serve the case conference brief 6 days before. There are certain scenarios where you may be the applicant, but you were the person who responded to the case. Because after, say your family was never in court before, and your former spouse brought an application to court, and you responded it with an answer. That's the first time you've ever been in court. And then along the way, you got a final order. That case is over. What happens after that is, if you or your former spouse or someone else interested in the case and has standing, they can bring what's called a motion to change the final order. And that's an entirely new case. But what happens, and this was a tricky thing that I struggled with in the beginning, was the applicant who brought that initial application before, that got that final order, they're still the applicant. They remain the applicant no matter how many times this comes back in court for either trying to change that final order the first time and it didn't work. They try to change the final order at another date, at another time. It becomes a new case. They're always the applicant, and the other person is always the respondent. So when we're talking about and the reason they do that is so it's not confusing to have applicant, oh, I was the applicant this time, but for this case now I'm the respondent. It could get confusing if there are several kind of volumes of that case, where final order, motion to change, final order, and then motion to change, final order the third time, or the third go around for this family. If it keeps flipping, it can be confusing. So the court wants to keep it simple. So the applicant and respondent would remain the same throughout. In the case conference context, if we're in the motion to change, but the respondent was the person who started that second volume of the case to try to change that final order that was made on the application, they're now the moving party, and they're the person who's responsible to serve and file their case conference brief 6 days before And then the person who was responding to that motion to change initially, they have the 4 days before. So don't get hung up on the applicant is always responsible for 6 days before. If they are the person who brought that new case, that motion to change, but they're still the applicant, sorry, if they're still the respondent, they're the person who is going to be responsible for that 6 days before. Now, having said all of that, don't wait for the last day of those deadlines. Again, somebody who loved to procrastinate, and is still lurking in there within me. I would wait until those last days, but don't do that because you don't know what's going to happen. If you have to print out material, the printer may not work. Or maybe you don't get a good Wi-Fi connection that day. You can't even print out, or you can't type out your material, whatever. Early and often is always best. Get it done. And as you heard in the presentation tonight, the case conference briefs are not necessarily call and response. It's not, okay, the person who asked the 6 days before, they do their case conference brief and then I respond to it. That's not how it has to be. Now, if they serve it before and they've said, well before 6 days, and there's something that you'd like to respond to in that brief, in your own brief, that's fine. But don't wait if the timeline is getting close to closing. Your brief is your standalone brief as to what you procedurally want to have happen to try to put your best foot forward for your case. So if you need financial disclosure from the other side that they haven't otherwise provided to you yet, those are the kinds of things that you would highlight in your case conference brief. Another thing, and we won't go into the details about it because I'm already ranting, but the one thing that the courts want us, lawyers and non-lawyers alike, to make sure they flag at a case conference is if you believe that if there are parenting issues in the case and the children are of an age perhaps where their wishes and preferences or their evidence needs to be before the court to help the court decide what is in their best interest, because that's all that matters, right, is their best interest. That's the golden rule. So if we can hear from the court or from the children, that's what the court wants. So at a case conference, as early as possible, which is a case conference, you want to be saying why you think the children's evidence should be heard in this case. And one way to do that is through the Office of the Children's Lawyer. So that is something that you should be flagging at that case conference. It's the court is wanting to hear from, again, if the children's wishes and preferences and their evidence is ascertainable, if they're of an age and maturity where they can give that, the court wants to know that, right? Because they can then give evidence, children can give evidence through a clinician or they can talk to their own lawyer through the Office of the Children's Lawyer, where they can talk about, the things that are going on in their life, what they value, what they want to see happen, what their schedule is, what their likes and dislikes are. So you can kind of hear that from the horse's mouth, so to speak. So that is something that should be also flagged at the beginning of the case, so that the court and the parties and lawyers, if there are lawyers involved, can do the necessary things like ordering the OCL, for example, or getting some other kind of assessment done, or some other kind of procedure where the children's evidence or their wishes and preferences as to what they want to do, where they want to be, and so forth, can be heard. It should be increasingly important that children's evidence is being before the court in an appropriate way, of course. The court does not want parents to be secretly recording their children questioning them about what they want to do and not want to do. Um, I can't stress enough to parents to not do that. It's not going to be helpful from the court or for the court, and uh, it should be discouraged. But there are these other avenues that I'm talking about that you should be flagging as soon as you can, and that opportunity is for a case conference. But I thank you folks for watching. Thank you to the students for a great job in relaying that information. It was great. So thank you to them. Thank you for thank you to Newton for setting this up. And thank you to Heatham once again. We couldn't think of a better partnership. So thank you very much.